Justice Clifford's here tonight. He, getting back to his bio, he served and he practiced in the city of Lewiston from 1964 to 1979. He served 3 terms on the Lewiston Board of Aldermen, 1 term as its president. He was elected to serve 2 terms as Lewiston's mayor during that time frame also. He served 2 terms in the Maine legislature, in the state senate from 1973 to 1976. And in 1979, Governor Joseph Brennan appointed him to the bench of the Superior Court. He was the first Chief Justice of the Superior Court, having been appointed to that position in 1984 by Chief Justice Vincent McCusick. And that job basically entailed overseeing the workings of the Superior Court. He was then appointed to the Maine Supreme Judicial Court, also known in Maine as the Law Court, in 1986 by Governor Brennan. And I believe he is the longest serving justice on the court until he stepped down just recently in 2009. During his tenure on the Maine Supreme Judicial Court, he served in various capacities as the liaison, for example, to the Advisory Committee on the Rules of Criminal Procedure and the Maine Assistance Program, just as some examples. Justice Clifford has a very long bio. He has a very long record in public service. You can ask him questions about it, but he is, we should be honored to have him here tonight. He served in all capacities of government, and he presently is still serving on the bench in an active retired capacity on the Maine Superior Court. And I myself have had the pleasure of practicing in front of Justice Clifford, and he's here tonight. Please give him a warm welcome for the Honorable Robert Clifford.
Thank you, Darren, for kind of a glowing introduction. I'm here to talk to you, and I'm happy to take questions at any time. And if what I talk about, I'm a judge, and I'm going to try to talk about the courts a little bit, but if you want to talk about something else, I'd be happy to take questions and to change the subject at any time. So, and I don't want to be, you know, when a judge speaks, usually a judge speaks in a courtroom, and when a judge speaks in a courtroom, half the judge's audience is disappointed in what the judge says. And when a judge speaks in public, he runs the risk of everyone being disappointed in what he says. And I don't want to be too long, and it reminds me of the story of the long-winded priest who gave very long sermons. And in the middle of one of these very long sermons, one of the parishioners who was sitting in the middle of the church got up and began to walk out of the church. And the priest said, "Mr. Simmons, where are you going?" And Mr. Simmons turns around and said, "Father, I'm going to get a haircut." And the priest says, "You should have got a haircut before Mass started." And Mr. Simmons says, "Father, before Mass started, I didn't need a haircut." So I hope I won't be too long, and as you know, we have a dual system of courts in this country. We have a state system and we have a federal system. And I know you're more interested in the state system because you have elections and you have appointments. But they're quite similar. And there is a big difference between the federal court system and the state court system. One of the systems has a lot of money. That's the federal system. And one of the other system does not, and that's the state court system. The systems that created the Constitution of the United States and of Maine creates the highest court, the Supreme Court of the United States under the federal Constitution, and the Supreme Court, the Supreme Judicial Court, it's called in Maine, under the state constitution. And then the legislature in the federal government, that's the Congress, and in the legislature in the state, they create the other courts. So that only the Supreme Court is mentioned and created by the Constitution. And judges are appointed in the federal system by the President and confirmed by the United States Senate. And in the state system, they're nominated, appointed by the governor, and they're confirmed by the legislature. Both houses have a say, but ultimately it's the Senate which confirms the state judge. So you have to go through a nominating process, and you have to be confirmed by the legislature. Federal judges have life tenure. Once they're appointed, there's not much you can do about it if you don't like them. State judges are appointed for 7-year terms, not a life tenure. That's a big difference between and under our system, the highest court is the Maine Supreme Judicial Court. That's our appellate court. And then we have the district courts, and we have the superior courts. The district courts is where the juvenile court is in the district court, and misdemeanors or less serious criminal cases are in the district court, and usually the family matters, divorces are in the district court, and the smaller civil disputes are in the district court. And the district court have no juries. The superior court is the only court that has the juries. That's where you have the murder trials, the more serious criminal offenses, and the more serious civil offenses. And the functions of a trial court, if you want to ask questions at any time, go ahead, or if you want me to talk about something else. I know you've been sitting through probably a lot of speeches, but there's a huge difference between what a trial court does and what an appellate court does. Very different. At the trial court, the judge or the jury, they determine what happens, what has happened in the past. The judge or a jury finds the facts, they apply the law to the facts, and they determine, one, if it's a criminal case, whether the defendant is guilty, and they have to do that, they have to find that beyond a reasonable doubt, or if it's a civil case, they determine whether the defendant is responsible for whatever injury the plaintiff has suffered, and they determine the damages that has been suffered. Now, the appellate court is the court that the case goes to after the trial court, and the appellate court reviews what happened in the trial court to determine if there was an error or if there was sufficient evidence. An appellate court does not retry the case. Appellate court does not retry the case. It only determines if there was some kind of error or if there was enough evidence to sustain what happened at the trial court. And the appellate court looks at the case with deference. In most cases that are appealed, the appeal is unsuccessful. Most cases are affirmed. And in the criminal, we have two kinds of cases, criminal and civil. Criminal is where the state brings an action against a person who they allege violates a criminal law. And the state prosecutes the case, either the district attorneys, and we have 8 district attorneys throughout the state, 8 prosecutorial district attorney districts, or the attorney general may prosecute some cases, and the attorney general prosecutes all the murder trials in Maine. The district attorneys do not do that. And the state carries the burden of proof. It's always the burden of the state to prove guilt of a defendant, and the state has to prove that beyond a reasonable doubt. And you have been convinced beyond a reasonable doubt if you have a conscientious belief that the charge is almost certainly true. That's the definition of reasonable doubt that we use in Maine. If you have a conscientious belief that the charge that's been brought is almost certainly true, then you have been convinced beyond a reasonable doubt. And until that happens, we're all protected by the presumption of innocence. Everybody who is charged with a criminal offense throughout the United States and in Maine is protected by the presumption of innocence. And that presumption protects you until a jury or a judge is convinced of your guilt of the elements of the offense beyond a reasonable doubt. So you may have a situation where a judge or a jury hears a criminal case and concludes that the defendant probably did it, probably committed the offense, but if they're not convinced beyond a reasonable doubt, then they have a duty to find the defendant not guilty. So you could have a situation where if you're a juror and you think the defendant probably committed a crime, but you're not convinced beyond a reasonable doubt, then you have a duty to find that defendant not guilty. You do not determine whether someone is innocent. You determine if the state has proved guilt beyond a reasonable doubt. And in a civil case, you have a plaintiff, usually a private citizen, or could be the state, against another private citizen or a corporation. And to prove a civil case, it's a lesser standard. It's easier. You prove it by a preponderance of the evidence, or by the greater weight of the evidence. And that is easy to define because the scales of justice, if they're even, then the plaintiff loses. If they're tilted in favor of the plaintiff wins, even if they're tilted just slightly. So if the scales are even or in favor of the defendant, the plaintiff loses. And at the trial level, the judge or the jury determines the historical facts, that is, what happened. And they don't determine it from their own investigation. They determine it from what is presented in the court through the evidence, witnesses and exhibits. And the trial, I'll just give you a brief overview of the trial, and I'll open it up for questions. A trial starts with opening statements by the attorneys who tell the jury what they think the evidence is going to show. And then the evidence comes in, most of it usually in the form of witness testimony. The witness is sworn to tell the truth, then is asked questions and relates the facts to which he or she may know about. And then the state goes first in a criminal case, and then the plaintiff goes first in a civil case, and then the defendant has an opportunity. And then after the evidence is finished, the attorneys make what is called a closing statement. They review the evidence and they review the law, and they attempt to persuade the jury or the judge, if it's a non-jury case, to find in their favor. And then, if it's a jury case, the judge is required to tell the jury what the law is. It's called jury instructions. The judge determines, the judge tells the jury what law to apply to the facts that the jury finds. And then the verdict, if it's a verdict, the jury makes that determination if it's guilty or not guilty, if it's a criminal case, or finding for the plaintiff or the defendant if it's a civil case. And if they find for the plaintiff, they have to determine the amount of damages that have been suffered by the plaintiff. And then after the trial is over, if someone is satisfied, they file an appeal, the notice of appeal, and they appeal in Maine. It's to the Supreme Judicial Court, sitting as the law court. And in most cases in Maine, you have a right to appeal. Appeal is a matter of right. Everyone has that right except the state. The state does not have the right to appeal in a criminal case if the state loses. The state has no right to appeal. And that's not the same with the United States Supreme Court. You don't have a right to appeal to the United States Supreme Court. You have to petition the United States Supreme Court, and they grant you the right if they feel that you should have the right. But you don't. In Maine, practically everyone has the right to an appeal to the Supreme Court of Maine. So we have the Supreme Court of Maine has many more appeals that they deal with than the Supreme Court of the United States. And one case that is in the news now is the case of State versus Dennis DeShane. Some of you may have read about that case. Dennis DeShane was convicted of homicide, of murder in the 1980s. He was convicted of strangulation, sexual abuse and strangulation of a 12-year-old girl in, I think, Bodenham or somewhere in Saginaw County. And he appealed to the Maine Supreme Court in his direct appeal. And that appeal was denied. We affirmed the conviction. I'm the one who wrote the opinion for the court in the first Dennis DeShane appeal. And then he has had several what are called post-conviction cases claiming that there's newly discovered evidence and especially DNA evidence, and he is seeking a new trial. He's had, I think this is the 5th total appeal that he's had, and normally you only can appeal once, but if you claim that there's newly discovered evidence, then maybe you'll be able to appeal in what is called a post-conviction appeal. So either the reason is that you have newly discovered evidence, or that your lawyer was not effective and deprived you of a fair trial. But in this DeShane's case, he is alleging that there's DNA evidence which he said he was not available, or that we didn't have the technology at the time of his trial, and that DNA evidence will determine that the DNA on the victim was that of a male, other than it was not Dennis DeShane, and therefore he is entitled to get a new trial to determine if maybe someone else had been the perpetrator of that homicide on that young girl. And there's two things, I'm going to open up for questions, but I want you to keep two things in mind which I think are very important. And that is and I hope that during the week here, when you're talking about government, that you get a chance to read and to contemplate the language in the Declaration of Independence, because that really is very important language. It says that our rights we don't depend on the state or the government for the rights, but the Declaration of Independence says we are all created equal and are endowed by our Creator with certain unalienable rights, that among them are life, liberty, and the pursuit of happiness, and that governments are created to secure those rights. And the Maine Constitution has similar language. It says we are born equally free and independent and have certain natural and unalienable rights, among which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety and happiness. So those are our rights that belong to us, and they come not from the government, not from the state, but because we are God's creatures, and we have those rights because they come from God and from the natural law. And so those are, our entire system is really based on that premises, that our rights are essential, that they can't be taken away lightly from us, because they are ours by nature, and by virtue of the fact that we are created and they come from God. So I think that you always ought to keep that in mind, that your rights should not be taken away without real serious justification or reasons, and because they are not created by the state, they don't come from the state, they come from a higher source. I'll be happy to answer any questions that you might have about the court system or about our system of government. Yes, sir.
I just had a question. What do you feel someone is entitled if they were sentenced for decades in jail, and then they do appeal and have a successful appeal? Can't say the word. What do you feel that they are entitled after being in jail for so long? Do you, like, I don't know, like, how do you feel that works? Like,
well, they can't. They only are entitled generally to one appeal.
All right.
All right, and the normal appeal, like DeShane had an appeal, and he lost. You only get an appeal long after, if you're in jail, only if you claim that there's some special reason, like your lawyer didn't represent you properly, or you discover new evidence, like, for example, DNA evidence. And that's been fairly common since the advent of DNA, is people who are long in jail now, because DNA, we know the DNA can disclose, blood and other body fluids. There's a lot of people who now are bringing post-convictions based on new DNA that at the time they were convicted, we didn't have the science to determine the DNA, and now there's a lot of people who have been released based on the science and new DNA. A lot of people who have been wrongly convicted, or a fair number anyway. So it's because of a lot of it is because of the change in the science and the new knowledge about DNA. Yes, sir.
How long have you practiced law as a lawyer before you became a judge?
I practiced for 15 years. I was a general practitioner. I lived in Lewiston. I had a general practice. I did some civil, some not much criminal, because one of my brothers was a district attorney, so I really couldn't do a lot of criminal cases. And I was involved I was on the city council or the board of aldermen, and I was the mayor, and I was doing that when I was practicing law. And it was a great background for me to become a judge, because I presided at city council meetings, and I was in public a lot, and it was a great background. And there's a famous letter that I think all you people who are considering becoming lawyers or going into the law, a famous judge in the United States Supreme Court during the 30s and the 40s. His name was Felix Frankfurter, and he was a professor at Harvard Law School, and then he became, President Roosevelt appointed him to a position on the Supreme Court. And he got a letter from a 12 or 13-year-old boy, and the letter said, asked him how he could prepare to become a lawyer. And Frankfurter's letter was a great letter. It's very short, and it says, my dear Paul, he said, no one can be a truly competent lawyer unless he or she is a cultivated person. If I were you, I would forget all about any technical preparation for the law. The best way to prepare for the law is to come to the study of the law as a well-read person. Thus, alone can one acquire the capacity to use the English language on paper and in speech, and with the habits of clear thinking, which only a true liberal education can give. No less important for a lawyer is the cultivation of imaginative faculties by reading poetry, seeing great paintings, listening to great music. Stock your mind with a deposit of much good reading, and widen and deepen your feelings by experiencing vicariously as much as possible the wonderful mysteries of the universe, and forget all about your future career. So don't worry about preparing to become a lawyer until you go to law school. Get as broad an education as you can, and that's very sound advice from one of the great justices. Yes?
I think the first question was more geared towards what do you think the person in jail is entitled to after spending so many years wrongfully in jail?
Wrongfully?
Yeah, if he feels that.
Oh, I didn't understand that. Okay, they in some cases they are awarded damages against the state for wrongful convictions. Some of them quite a bit of money. Yes.
Are they able to sue in any of those cases?
Yeah, that's how they get. They sue, and then the result usually is a settlement, and some of them have been on death row, where DNA has found that DNA has proved that they are not the person. Yes.
I was just wondering, as a practicing judge, could you maybe go through like the methods, maybe like a checklist of what you did before you made your final decision after seeing the facts?
Well, you got to. If sometimes the judge is not the fact finder. If there's a jury case, the jury does that. But if you're the fact finder, what you got to do is you got to assess the testimony of the witnesses, and you got to determine, what the witness's age, the witness's demeanor, Is the witness's testimony, does it seem truthful? Is it consistent with his or her own testimony? Is it inconsistent? Does the witness have a motive or an interest in the case? You know, what you do is you apply human nature to assessing, as you do in your daily life when you meet with people and you have to assess whether you think that person, you know, you're getting a good deal in buying something. You just bring your common sense and try to determine who do you think is you know, telling more of the truth. And it may be, you know, that it's not black and white where everyone gets up and either tells the complete truth or tells a complete lie. I mean, people see things differently. So sometimes two people can see the same thing or the same facts and really relate a different story because they see it differently. So you have to go through all of that, and you just use your common sense and try to use your experience in determining. And then you've got to keep in mind who has the burden. If you're not persuaded, then the state may lose and the plaintiff may lose if you're just not persuaded one way or another. So it's human nature. You have to assess how you think, you know, which witnesses are closer to the truth. Yes, sir.
Thank you. How in high-profile cases, how effective do you believe juries are, and how effective are people at battling corruption in the jury?
I don't think there's much corruption in juries. In Maine, we don't have a lot of, one thing, I know you're running for governor and legislature and that stuff, and I think it's a great exercise. One thing that we have, I think in Maine, that we can be proud of, is that we have very little public corruption. That is, people on the take. I think that we have very little of that in Maine. You know, as opposed to, my apologies to those from Massachusetts or from New Jersey or some other places. We really have, it's not in our culture. We don't have it in our culture. I know many years ago my son went to a college in Massachusetts, and several years after he graduated, one of his classmates and teammates called me up on a Sunday night at my home in Lewiston, and he'd been skiing in Sugarloaf. And he told me he got caught for speeding. And kind of there was a long silence. I think, you know, I think being in Massachusetts, he thought that I could fix his ticket. And I said, no, first of all, I don't think I could fix the ticket, but it just never would occur to me to try to do that. So in Maine, I think we have a lot of, we don't have a lot of public corruption, but a jury, we constantly instruct a jury that they're not supposed to have any contacts with the case when they're sitting on the case. They're not supposed to talk about it. They're not supposed to read about it. And recently we've had to instruct jurors to keep off social media, so they won't start talking about being a juror on Facebook or on whatever the Twitter or whatever the other things are. Did I answer that? Did I answer the question?
Yes.
Okay. Yes.
You said that people absorb like truth at different things. Is it true that lawyers don't always want a lot of witnesses, so people make assumptions and then throw out the case?
Well, if you got a lot of good witnesses, you want to use them, but if you don't, you wish you had some more. It depends on, you know, every case is different, and Derek Bander, he's on the staff here. He's a trial lawyer, a good trial lawyer from a very experienced law firm, and he could tell you, being a lawyer in a trial lawyer is very stressful. You know, there's a lot of tension that goes on in a courtroom. Yes.
What do you think of the new studies being done that show how ineffective witnesses really are? Like an eyewitness report, a lot of studies now are saying that they really shouldn't be taken very seriously.
Well, there's a lot of studies that, you know, the old saying was that I'd never forget that face because there was so much stress, and that face has been imprinted on my brain. But a lot of studies show that the more stress, that a witness is going through, the less reliable the witness's memory is going to be. There's a lot of studies that show that. And I allowed one time when I was a trial judge, I allowed an expert witness to testify to that fact in front of the jury, to testify that studies show that the more stress there is in the circumstances of the identification, the less likely it's going to be a reliable identification. Is someone over here? Yes.
Where do you stand on the death penalty in the state of Maine?
I'm not a big fan of the death penalty, and the reason is the death penalty would make a lot more sense to me if it weren't for the amount of due process that the courts require when there's a death penalty case, so that the person is not executed for 20, 25 years. And the amount of due process, we'd have to have a lot more people in the Attorney General's office to defend death penalty cases. There's a lot of the due process in a death penalty case is practically endless. They can appeal and reappeal and reappeal. And I think it actually ends up being more expensive to have the death penalty than if the person were executed. You didn't have to pay the cost of housing them in prison. Yes?
Where do you stand on rehabilitating criminals in this society?
Well, we always hope. That's one of the legislature has set out certain policies that we want to accomplish in sentencing people. Sentencing, by the way, is difficult. It never gets easier. I've been a judge for a long time. Sentencing is not fun and it's not easy. Rehabilitation is one of the factors that you consider when you sentence somebody. But so is deterrence, and so is punishment. And you know, there's a lot of different conflicting policies that you have to consider when you're sentencing somebody. Juvenile law, for example, is entirely based on rehabilitation and not punishment. The juvenile code is geared almost exclusively to rehabilitate juveniles, whereas the adult criminal law, rehabilitation is one factor that you factor in, and you hope that's why we have probation. We hope that the person is rehabilitated and goes on and leads a good life. It doesn't always happen. There's a lot of recidivism, but it's one of the. It's a strong factor. I can't. The gentleman up back there, you've had your hand up. Yes.
My name is Paul Babrak, and earlier you described the criteria to how you would go about a case. I was wondering if you could tell us a case or a situation where you were torn between two sides and you had to choose.
The most interesting case that I had was State versus Nancy Fredette. Nancy Fredette was a woman who lived in Biddeford, and she was married to Fred Fredette. I was a very new judge. Fred Fredette was found dead in his bed in the morning, and Nancy was in the house. And Nancy, her story was that an intruder had come in the back door. This was a fairly small apartment, and had shot her husband and then ran out the door. And she said that she was stuck in the bathroom because when she went to open the bathroom door, it was stuck against the back door where the intruder had come in. So she said she couldn't get out of the bathroom to see who it was. Well, the police came and they were all over the house, you know, taking evidence. And one of the state troopers, he tried to make the door stick. He couldn't do it. In other words, when you open the bathroom door against the apartment door, it did not stick like she said it stuck. He couldn't make it stick. And the day of the murder, the husband had an appointment at the bank, and the purpose was to go over, he was missing $7,000, and they were going to review with him that day what had happened to the $7,000. And it turns out that Mrs. Fredette had withdrawn $7,000 using Mr. Fredette's signature over a period of months. The gun that was used in the homicide was found in the house. It was it was in the washing machine. It was tucked under some towels that had spun dry. The gun belonged to Mrs. Fredette. And she had reported it stolen about a month before. There was a glove found in the bedroom with powder burns on it. And the glove belonged to Mrs. Fredette. And about a month before the homicide, Mrs. Fredette called the police to report that an intruder had come into their house and set her husband's bed on fire. And so Mrs. Fredette was charged with murder. About 6 months before that time, a witness testified that Mrs. Fredette had paid him $3,500 to find someone to kill her husband. And it was the same day that there was a $3,500 withdrawal from the husband's account, with Mrs. Fredette forging the signature. Well, I was appointed a judge in 1979, and I was assigned to that case. And that case, because it was a very high-profile case, it happened in Biddeford, it was transferred for the first trial to Skowhegan. And it was tried, and the jury was not able to agree. There was a hung jury. It was 10-2, I think, in favor of conviction. So there was a new trial, and the second trial was held in Wiscasset, in Lincoln County. And the jury convicted Mrs. Fredette. And then she appealed to this law court, and they ruled that I had made an error on the evidence. And they gave, I was at the law court for a long time, and they gave her a new trial. And so the third trial was held in South Paris, in Oxford County. And I was the judge in all 3 trials. And in the third trial, the jury found Mrs. Fredette not guilty. So it was a fascinating case because it was a whodunit. She denied that she killed him. She claimed it was an intruder. Most murders, you know, it's a question of whether it's manslaughter or murder. This was a whodunit. She claimed that it was murder, but there was a lot of evidence. You know, the state had a pretty strong case, but they found Mrs. Fredette not guilty. And now both, because Mr. Fredette had died at the time, and Mrs. Fredette has since deceased. And so only the good Lord knows. But that was a fascinating case for me because it was, each of the trials took like 2 weeks. Long trial. I was very new, at least the first time, and it was a bizarre case. So the lesson is, if you're a prosecutor and you want to have someone convicted, see if the trial can be switched to Wiscasset. And if you want someone to be acquitted, take them to South Paris. Yes.
First off, I'd like to thank you for your service for not only Maine, but our country. And my question is, with your military background, how did that affect your, you being a justice?
Well, the military was good for me. I was in, you know, when I was in college at the time, the draft, everyone had to serve. So we were all, and I went into ROTC, and I went to law school right after college, and when I went in the military, I was a lawyer, but I didn't want to spend the 4 or 5 years that would have required if I wanted to be a lawyer in the military. So I became an adjutant to a regimental commander, and I had a great job, and I had a great time, and I have a lot of respect for the military. And I had a command of a headquarters company, so that was I matured a lot in the military. I really did a lot of maturing in the military. It was very good for me, and I learned some leadership skills in the military. So I'm very positive about military service for everybody. But you know, it was easier for me. We didn't have, there was no, it was before Vietnam heated up, and it was before Iraq and Afghanistan. So it's easy for me to say that, you know, it was a great experience because it's much tougher over there now than it was when I was And I spent 2 years in Germany. And so it was, relatively, it was great duty, but I have a lot of respect for that, and the military did me a lot of good.